maintaining a little suspense. It appears my friends in the majority have forgotten that lesson because there's no suspense here. We knew that Mrs. Myers would not come today. We know she'd been instructed by the President not to appear. We know she'd been instructed not to testify. We know she had been instructed not to provide documents. We know that this investigation is proceeding only because it's been sold on the basis of a string of fallacies. The first fallacy, we don't know who put the U.S. attorneys on the list, but we do. The fact is, Kyle Sampson did, after checking with top justice officials in the know and drawing a consensus from their opinions. When the list was final, he gave it to the Attorney General as a final recommendation. None of this was illegal or unethical. Fallacy two, we don't know who decided to fire the U.S. attorneys. But of course we do. The Attorney General did. Only in Washington could politicians feign shock and disbelief at political appointees being fired by another political appointee. Fallacy three, we don't know why the attorneys were fired. The fact is we do, and none of those reasons appears to have been about hindering prosecution of Republicans or obstructing justice. The witnesses have consistently articulated innocent reasons why the U.S. attorneys were fired, including not vigorously prosecuting the President's priorities, like ending illegal immigrant smuggling and prosecuting gun crimes. The Attorney General stands behind the decisions to this day, as does the Deputy Attorney General. Fallacy four, we don't know if the U.S. attorneys were fired to protect Republicans from prosecution and guarantee prosecution of Democrats. The fact is we do. David Margolis, the top career official sitting at the pinnacle of the Justice Department, didn't detect a whiff of any such shenanigans and says anyone who would have suggested them would have gotten his, that is David Margolis, sharp stick in the eye. Even the Democrats' contract investigator told the minority that if David Margolis says it happened that way, it did. You can take it to the bank, he advised. We're paying $250,000 for this man's advice. We probably should take it. Fallacy five, we don't know enough about what the White House did, and they won't tell us. The fact is we know plenty, and the White House has long offered to tell us more. The Democrats just don't like what they hear. The truth appears to be simple. The White House's involvement in the Justice Department's review was neither nefarious nor in-depth. The White House awaited the results of the process conducted for the Attorney General by Kyle Sampson and others, offered input when asked, and at some point asked how it was going. Nothing uncovered thus far in any way indicates anything illegal, unethical, or untoward. This week, our staff once again spent hours, interviewing Kyle Sampson, and he could hardly have made it clear that the White House did not meddle in the dismissal of the U.S. attorneys to seek partisan advantage in prosecutions. I commend the interview to all members' immediate attention and evaluation. So we don't genuinely need Ms. Myers' information, and we don't need an executive privilege showdown. I think we know enough right now to call out the accusations of the White House wrongdoing for what they are. Smoke and mirrors. There's something we do need. Teetering on the brink of threatened contempt proceedings, we need the majority to drop the smokescreen of their accusations and present real, hard evidence, if they have it. We might get to a showy court confrontation if we vote for contempt, but we don't win in court unless we have evidence. And here I speak as a member of the House and not as a partisan. This is of vital importance, I think, to me personally and to this institution. As every member knows, to overcome the presidential privilege, it is necessary to demonstrate with specificity why it is likely that the subpoenaed materials contain important evidence and why this evidence or equivalent evidence is not practically available from another source. In short, the courts will call on us to show the information sought is demonstrably critical to the responsible fulfillment of the committee's functions. So I challenge the majority right now to present evidence and only evidence to the American people and the minority. I challenge the majority to cite and produce specific passages of hearing testimony, interview testimony, or documents that demonstrate that there remains, in this case, a critical question that has been left unanswered and can be answered only by information from Ms. Myers or other White House sources. If you can't do that today, after 5 months of incessant investigation, nearing 10,000 pages of documents, myriad interviews, and 13 prior hearings, how then can any of us here in Congress or out in the public believe that this investigation is anything other than a preposterous, prefabricated, partisan sham? How can we conclude this controversy is anything other than a gigantic spin game, frittering away the precious time of this 110th Congress, of which we have precious little to address the monumental problems confronting the nation? Spinning is rebuffed at the courthouse door. When the spinning stops, the courts having observed the facts, don't hesitate to say that the emperor has no clothes. If we go to court, we fear that that will be the result in this case, much to the embarrassment of the 110th Congress. It is time for the majority to stop swaggering its power in this Congress, to clothe itself in prudence, and to back off this pointless constitutional showdown, or provide evidence to the contrary.
The time of the gentleman has expired. Thank you for your statement. I would now like to recognize Mr. Conyers, a distinguished member of the subcommittee and the chairman of the Committee on the Judiciary. Mr. Conyers.
Thank